Earlier, it used to be very difficult. We used to reach out to law firms, seek a help from the local lawyers. Now things have changed. I have a team of about 45 people. What is the job? With AI coming in, ChatGPT coming in, your job will be gone if you are traditionally, you're cocooned around contracts, cocooned around small legal advices, cocooned around identifying the disputes and going to a lawyer for litigation or arbitration. Now things have changed. Now you have to read and understand the law, and maybe AI will help you positively for that. But sitting in your office, you have to advise the company regarding whether or not you are permitted to enter a particular market, invest in that, what type of business you can do, what is the nature of documentation that you need to produce, understand the complete regulations there for commercializing your product in the territory, bringing back the money into India, investing in that country. So it's a huge area. So AI helps you. So I want the in-house team, and the in-house team today, as Satish rightly pointed out, you have to learn business, but it's not just business, right? The lawyers themselves, in-house counsels themselves metamorphose into that. Coming from the opposite side, I think, as I said, policy advocacy is an important thing. I would just want to touch upon one thing which Tabrez said. In the future, probably prescriptions will be made online. So online area where we have, consultations, teleconsultations, online consultations happening. But this is a highly regulated market. The more number of regulations are coming in, it is not reducing. The number of regulations are not reducing. We are grappling with technology, we are grappling with digital, we are grappling with disruptive practices, new things coming in. The number of regulations are not coming down. And therefore, lawyers, please don't be under an impression that you will be out of this profession because the sheer number of traditional legal work might reduce. But there are other avenues which are being opened up in terms of understanding regulations, technologies, e-commerce platforms, the new things, digital interface between a pharma company and a doctor and a patient. The B2C, which you had referred to earlier, it's exactly happening. Earlier, we used to do a B2B. We have business in 100 plus countries, for example. And now things have changed because of technology. You're directly interacting with a consumer or a patient. And with that comes in a lot of challenges also. So I stop at that.
So let me disclose what I'm focusing on as a new sector of interest because of technology disruptions. And maybe you want to engage with it or not, I'd leave that up to you. But the way I have pivoted my practice, at least, is I've started focusing on international commercial space law. So that's outer space, satellites, technologies that are space allied. And it goes to why technology and being aware of what's coming next is important for both, not just law students, but also for lawyers. The way the sector in law works is you can envision it as sort of a risk tide, that there's a new disruptive technology that enters the market in a complete vacuum of regulation. And then there's one big landmark dispute or case that happens because of that technology, which sort of facilitates the need for the state to step in and say that this is a problem and it requires regulation. So step 3 then becomes the regulation of it, and then the output of how that regulation is in fact enforced in the market. So with AI, at this moment, we are at the regulation stage where we are trying to figure out how best to regulate it, because we've seen that it's disruptive, it's going to have a vast impact, and now we are at step 3 to sort of suggest what is the regulation that comes out of it. Space is probably a step before that, where there is no real understanding of whether the framework to regulate commercial space activities should be general, should be specific, should be fragmented, and which is why I thought I may have the first mover advantage in this space, because not a lot of people are doing it. We don't know what it'll transform into, and it's a sort of nice niche to develop. So if you are approaching your legal profession, envisioning sectors from that risk tide to essentially see what stage of legal development a certain disruptive aspect or sector is in may be a good way to sort of figure out what are the areas that you eventually want to specialize in.
I'll start with a story. You know, quite early on in my career, I remember I was doing a case for PepsiCo, and the general counsel told me that, look, we have a sort of a similar issue coming up. Can you just chat with my assistant manager on that? So this gentleman from a sort of far-off plant, you know, takes a 2-hour ride to come and see me. And, you know, I was young, a newly minted lawyer with that arrogance that I knew the law. Within 10 minutes, I realized that that individual knew every legislation that related to his business. He knew everything about the law, he knew everything about the regulations, he knew everything that needed to be known in the book. What he wanted from me was something more, something extra, something additional. Now, that's something that's always stuck with me. And now, you know, if I look towards my right, I have sort of two levels of clients. My client is a law firm, and their client is an in-house counsel, whose client is ultimately their own business. So what is going to be expected of each of you is going to be bringing something extra. Now, in terms of, you know, the big sector that's booming is going to be data, be it from a dispute perspective, be it from a sort of a non-dispute perspective. But as Pranay said, there's so many other things that are happening. It doesn't mean that you just need to go with one sector. You might have a very different interest. You might have an interest in something more traditional. But even that sector, like, you know, something as traditional as construction is being disrupted by technology. So it doesn't matter what you choose, but what you will need to always bear in mind that you are going to be required to bring something extra, because there will be times you need to get into the details. When I appear in an English High Court or before an arbitral tribunal, I need to sometimes get into the nitty-gritties of what that particular dispute is. How does a gas pipeline work? What happened at that point in time? And sometimes your clients will ask you, as has already been said, to advise you on policy. But again, these will be very sophisticated clients who understand how that whole business works, who understand how that industry works. What you will be required to bring something extra. And in this day and age, to do that, you will have to learn how to deal with a tremendous amount of information, consume it and process it and come up with something very simple. Because when your client, be it this client, be it that client or the end client, they want an answer. They don't want a memo, a 50-page memo.
So with that, I open the floor. I have asked for a few more minutes. Any question? Go ahead, please. And tell your name, tell who is addressed, who should address this question. Go ahead.
Hi, I'm Navdeep. I'm a senior associate at Advani Law. My question is primarily for Abhayan and Satish. So one thing I feel like that doesn't get talked about enough is the IPR landscape and the disruptions in it and the disputes in it due to technology, especially after 2019, everything's just become online. I want to know, especially due to the nature of the companies that you work with, how much have the disputes, how much have the IPR disputes increased ever since technology adoption became more and more and more? And especially Abhayan, because I personally in my practice, I see a lot of IPR disputes in India in the pharmaceutical sector, so I want to know from you guys.
Want to start? So I have 5 more minutes only, so please be brief. There might be a second question also.
Okay, so on the IPR dispute, I will say I can give one statement. I am looking for an IPR attorney for $200 million dispute right now, as we speak. I am looking for a IPR dispute attorney for $200 million or even more. So there is a huge demand for IPR disputes. So another dispute that I am handling is killing a competitor. So that sums it all.
Don't talk about that. You will be anti-competition.
Okay.
Please pass the mic to the next one. Only two questions, please. Rest, let's take it.
Do I?
Good morning, everyone.
Okay.
Myself, Randeep.
So,
I'm a
two,
student.
so one second. So two things. One, the IPR disputes, in my view, at least from my experience, it becomes more easier for people to identify infringements, etc., and raise disputes. Traditionally, as an industry, we used to fight with each other. Now that strategy has changed slightly. So the patent law, if you would see, now it is more of in-licensing transactions and making available drugs. But to answer your question straight, yes, the digitalization of data. For example, if I had to take a e-discovery proceeding, I would have taken 10 laptops and taken somewhere. Now it's readily available. So it's very easy for people to file it. 15,000 plus trademarks in which you're handling in the pharma industry, multiple trademarks are almost identical. Very challenging. Disputes are galore.
Good morning, everyone. Myself, Randeep. I'm a student from Faculty of Law. I have a question that how much reliable the data that AI softwares provide these days to us. Like we put up 1,000 pages of file and we ask some questions to it, but how much reliable that data it outputs to us is going to be.